Okay, moving on. We're now going to have a panel discussion, and I want to thank in advance each of our panelists for sharing their insights with us today. Also, of course, the DA and Tanish also. As is our custom, each panelist will have 5 minutes. I'm going to be a school marm about this to make sure that to keep everybody to 5 minutes, to keep your opening remarks brief, because the best part of our conversation is really the Q&A afterwards with the committee members. So with that said, let me make some introductions. Gay Hardwick, can you turn on their cameras? Ms. Hardwick, are you there? Okay, we will. Hopefully she'll be back. Holly Fleming, she's the program coordinator from Children's Advocacy Centers of California. Allison Kephart, am I pronouncing your name correctly? Okay, good. She is the Chief Operating Officer of Weave. And I know that you have a time constraint, so I'm going to ask you to go first, fair warning. And then Jess Nickel and Annie Nickel, who are survivor advocates and partners with Crime Survivors Speak. It's been a long time since I've seen you both. It's good to see you. Thank you for joining us. And Ms. Keffert, if you could start things off.
Yes, thank you so much. And I appreciate putting me first, and I apologize for my schedule constraints. Thank you for having me. As you mentioned, I am the Chief Operating Officer with Weave. Weave is Sacramento County's largest provider of services to victims of domestic violence and sexual assault. We are the Rape Crisis Center for the county. We have been around since 1978. We are one of only 2 state-recognized shelter-based DV services programs in this county, serving about 1.6 million residents. So we do a lot here. My role is to supervise and support all of our direct services programs. So I kind of see everything that comes through our doors, through our shelter programs, through our therapeutic counseling, through our legal advocacy programs, all of that. I'm also a licensed attorney, and my background and expertise is in family law, specifically, and in particularly in the intersection between domestic violence and custody, financial matters, those kinds of things. And then over the years of working with survivors, I've obviously seen intersections with lots of other things, including the criminal justice process. So one of those intersections is one of the things before the committee today, which is really the role of victims in the criminal justice process. And in particular, the thing that I discussed with Mr. Owen was the role of victims in the issuance of protective orders. And I think that's a thing we see come up quite a lot for our survivors. So I'm really looking forward to discussing it, because I think it's a place where victims do, unfortunately, it's a system that's designed to help protect and support them. And it's a place where they're oftentimes an afterthought. They maybe are not aware of the fact that an order has even been issued that protects them. Many of the survivors that we serve are protected by a criminal protective order, and they don't even have a copy of it because they weren't present at the arraignment hearing where it was issued. Or there is a plea bargain being negotiated, like what was being discussed earlier, and it may or may not include a protective order when they really have all the information about what would keep their family safe, and they're not included in that discussion. Or they don't have a clear mechanism to modify an order after a proceeding has concluded. So I'm really hopeful we can talk about some of those things and ways that we can include survivors. So thank you for including me today.
After all this time with Zoom, I still forget to take us off. Ms. Hardwick, I didn't get to properly introduce you. You're the co-founder of Phyllis's Garden. I was wondering if you could tell us a little bit about your work and how we might be useful to, anyway, your experience and how the committee might be useful to crime victims.
Thank you for having me today. Despite my technological difficulties, I made it here. Phyllis's Garden is a real grassroots organization started by victims of the Golden State Killer. Chris and I and Phyllis were all victims of the Golden State Killer, and we know firsthand what it's like to carry the burden of trauma for decades. So while Joe D'Angelo is serving a life sentence at the moment. We've already served 45 years of our life sentences. We were very pleased with the court process that we participated in and our ability to give our victim impact statements. And we realized that not very many victims have that opportunity in real life. And so we feel very fortunate that that helped all of us on our healing path. We decided to find a way to sort of pay forward the opportunity we had to find our voices, get back on the healing path, help others and each other to be resilient in the face of adversity. And that's kind of our mission these days. And one of the things we thought about was, well, what could we do? What is a solution that could help victims directly that we could participate in? So we came across the concept of soft interview rooms for victims of violent crimes. And we found that our local police stations and sheriff stations are sorely lacking in those amenities. What we found was that when we visited even my local police station here in Lodi, that victims are just shown into the same rooms where criminals are, interviewed. And it's a very stark, sterile environment, sometimes with a tin table and hooks for handcuffs and tin chairs. And not much had changed in 40 some years. It's very intimidating, and it's not conducive for a victim to feel comfortable, feel safe, and to be able to remember the details of the trauma that they've just experienced. So we did our first soft interview room at the Central Sheriff Station on Florin in Sacramento about 2 years ago. And since then, we've done 12 more, and we've funded them all on donations that my partner, Chris Pedretti, and I have raised. Each room costs about between $3,000 and $4,000 to outfit. And it makes a difference. It makes a huge difference. Chris has been speaking in cadet trainings and detective trainings for several years now, and found that the detectives and cadets are interested in becoming trauma informed. But when they go back to their police stations, there's not much environmentally they can do to create a safe, welcoming, warm environment where a victim can feel safe, can remember details, will not mind if they think of additional information that could be helpful to law enforcement a week later, and they will come back when they're treated in this way. So in a lot of ways, the rooms help police officers and sheriff's officers to close more cases because, as we know, a lot of victims don't press charges. A lot of them don't report, and it's because it's so intimidating to do so. So that's what our main impetus has been. And I don't know if you can see this, but this is
Oh, that's fantastic. I was
that's
gonna
a
ask if you have
before.
pictures. This is exactly what we wanted. Yeah, go ahead.
That's the before at Florin Road, and this is after.
That's great.
So, it's warm lighting. We have chairs that move and help a victim to process their anxiety while they're telling their story. There are blankets if somebody needs the security of a blanket that they can take home with them, fidget toys. There is surveillance equipment in the room, and the victim is informed of those, but they're not obtrusive.
I'm sorry to cut you off. I want to keep
Yes.
everybody at 5 minutes. First of all, I was remiss in saying this at it should have been said at the beginning when Tanisha's here. I really appreciate that even just coming in advocating for some of these issues, is also just kind of being part of a process that you never wanted to be brought into in the first place. So extra thank you for being here. Ms. Fleming.
Hi, good afternoon now. I'm Holly Fleming. I'm the program director for Children's Advocacy Centers of California. We provide training and technical assistance to the folks who respond to allegations of child abuse throughout the state of California. Our work ties really nicely in with everyone who's been speaking today. Children's advocacy centers all host soft rooms for a place for kids to speak about what has happened to them to trained experts. They also provide multidisciplinary team coordination in the state. So it is the law that every county has to have a MDT response to an allegation of child abuse. And 44 counties use CACs to do that.
Well, hold on.
Yeah.
MDT.
Oh,
I mean, it's not your fault. This whole system is an alphabet soup of things. So if you could,
totally.
okay.
Yeah, I apologize. I've been doing this work for 11 years. Sometimes I forget. MDT is a multidisciplinary team response. So ideally, when there's an allegation of child abuse, there's a team of people who respond to that. So it would include law enforcement, child protective services if that's needed in the case. Medical folks, oftentimes a prosecutor will be involved, mental health services, and in communities that use children's advocacy centers, it includes a forensic interview and a family advocate who's the person who meets with a non-offending caregiver at the time. Okay, great. So in California, we have 55 CACs and MDTs who are serving 44 counties, and their structures really vary in the state. We are a very county rights-based state. So we go from our most common type being government-based agencies. So these are children's advocacy centers that are based out of district attorney's offices or CPS. And then our second most common is nonprofit organizations that provide that kind of coordination and services through the county. And then the third are hospital-based. Now, CACs are really important primarily because they keep the victim at the center of the investigation into the allegation. Children who go through a CAC are 2 times more likely to get a medical forensic exam for what happened to them. They're also more likely to get into mental health services, and those mental health services are more likely to be empirically backed, especially for this type of trauma. And also communities who use CACs save money. On average, it's $1,000 per child for an investigation is saved in using these. So in our state, CACs are still pretty fledgling, which is really interesting considering we have the most children of any state, but we are a bit behind in considering children, especially in terms of surviving crime in the state. So I appreciate you taking the time to hear from me today.
Thank you so much. Also, thank you for staying within your allotted time. Jess and Annie Nickel. It's been some time since I've seen you both. Thank you for joining us, and take it away.
Good morning, committee members. Thank you for inviting us to speak today. We are Annie and Jess Nickel, and 32 years.
Oops, Annie, we lost you.
We lost Annie.
Trauma was co-opted to.
Oh, wait, Annie, I'm sorry.
Yes.
You got. Could you just back up 30 seconds?
Sure.
Because you froze for a minute. So.
Oh, I'm sorry about that.
30,
Go from the
32
start again, yeah.
Yeah,
From the
32
start.
years ago. Yeah, basically from then on. Start, ladies and gentlemen, Annie Nickel.
Oh, no.
You're jinxing her, Mike. You're jinxing her.
12-year-old sister, Polly Klaas, was kidnapped from our bedroom and murdered. We are here today not to recount that tragedy, but to address how our family's trauma was co-opted to advance policies that have caused immeasurable harm while failing to deliver justice or safety. We want to be clear from the outset that we are both high-profile victims who received enormous public validation for our loss, which is a privilege most victims never receive in the wake of losing a loved one to violence. Yet even with that validation, we've been re-traumatized countless times. Our pain has been turned into true crime entertainment by the very law enforcement officials who investigated our sister's case. Politicians and lawmakers have exploited Polly's memory to push punitive agendas that have dramatically expanded mass incarceration, particularly strikes. 3 strikes laws were passed when we were children. We had no voice in how our sister would be remembered. And yet, decades later, it is we, Polly's sister, who carry the shame of how much harm these laws have caused in Polly's name. There is real harm in co-opting victims' voices and using our pain to punish people. I remember just months after Polly was killed, when I was 7 years old, I was sent to the White House and asked to tell the president on national television that I was afraid I wouldn't live to grow up because of all the bad people in the world, so that he in turn could tell me that he would do something about that.
Yikes.
The political agenda I couldn't comprehend. Yes, sorry.
You just froze again. So keep on going. I'm sorry.
Okay. This is just to say it's a moral injury I carry to this day, and I believe the justice system has an obligation to protect people in their most vulnerable moments rather than exploiting our grief for political gain. And I'll pass it off to Jess now.
Thank you. So I want to talk about justice now, because our family is the model of what justice looks like in this country. So here's what happened in our case. The man who kidnapped and killed our sister was caught and found guilty of doing it, and he received a death sentence. And legislation was passed in our name, increasing mass incarceration in the US. But after decades of reflecting, here's where we've arrived. This form of justice didn't actually bring us healing. We found our way with healing in spite of what the justice system offered us. And we've come to realize that what the justice system offers victims is inadequate and fails to deliver what victims really need in the aftermath of a tragedy. So an important fact to consider is most cases of violence aren't like ours, where a stranger breaks into a home and commits a horrific act. Most violence happens between people who know each other. And in those cases, victims and survivors need something different. So they need repair and real accountability. I know Tanisha was talking a lot about that, rather than just only punishment. And this is why we think that judicial discretion is really important rather than just mandatory sentences written by legislators. And victims should have a real voice in what happens, especially in non-fatal cases, because what they need isn't always just the maximum punishment. Okay, finally, one thing we've come to understand is that the way that people relate to us as high-profile victims is the flip side of how people with less public validation are treated. So where we are exploited, they are erased or invalidated, and neither side is treated humanely. And this is the thing that we hear over and over talking with other victims and survivors, and it matches our experience too, is that victims don't feel like they're being treated humanely. This is why we believe that trauma-informed training and certification must be integrated into every aspect of the justice system, from law enforcement and prosecution to victim services and the legislative process. This would support victims and survivors, regardless of their visibility, to be treated with dignity and care, rather than being used as political tools or forgotten entirely. We believe that treating victims in trauma-informed ways is essential for public safety.
Sorry, I keep on trying to interrupt you, and I reluctantly, Jess.
Well, that's it.
Okay, good. So I, as somebody who's devoted my life to talking about the 3 strikes law, I've known Jess and Annie for, some time, and can't respect them enough for what they've said about the 3 strikes law. So I just want to take 30 seconds in this forum to say, particularly to Annie and her experience at the White House when she was 7 years old, and that you carry shame about that, is, I apologize, and that's ridiculous. not ridiculous that you carry the shame, but that you should carry that shame. That's not your fault. That is the adults around the room who let that happen to you, including the president. And who was it? I forget who was the broadcaster.
Say again, sorry.
Who's the broadcaster? I mean,
It was Peter Jennings and
yeah, it's
Bill
Peter.
Clinton, yes.
I mean, you shouldn't because it's horrible, but to find on YouTube Annie when she's 7 years old sitting with Peter Jennings and the president to talk about this stuff, the largest crime bill in U.S. history, is just something to behold. All right. With that said, I want to try to find ways that we can make some practical impact and benefit to crime survivors. Again, acknowledging that it's impossible. It's impossible to make people whole. But what can we do to make things a little bit more sensible? Ms. Hardwick, I think the idea of soft interview rooms, it seems to go hand in glove with Ms. Fleming was saying, especially for children. Um, are have you are there, aside from you guys just raising money and walking into a police department and saying, here's $5,000, can you buy some nicer furniture? Are there legislative fixes or that you can imagine?
Well, yes. I mean, I think California is making strides in doing trauma-informed training with police forces, law enforcement in general, and with district attorneys' offices. And but what's lacking is follow through. The tools that the officers need to make the traumatized victim feel safe like they know they should, and believed like they know they should. And those things are just lacking. There's no budget for them. And it seems like a small thing to ask with all of the money that is spent, that $3,500 or $4,000 be allocated to taking a space in a public building and making it for victims. And we do that for children much better than we do for adults. They hardly exist at all for adults. But we have done 2 sexual assault forensic exam interview rooms over at the Sacramento
And when you say we've
Regional
done,
Family
you
Justice.
budget, or when you say we've done, what does that mean?
Like we've been given, the space to create a soft room within that building.
And then you guys fund it. I mean, it's like, is that correct?
Yes, Phyllis's Garden funds it. And it's just, it's like this piece is missing in creating trauma-informed policing.
I hear that. Ms. Kefart, you raised your hand. Go ahead. I had a question for you, but you go first.
No, that's fine. Go right ahead.
Well, I wanted to, so we were talking about the protective orders and whether or not, the victims of those, or the people supposedly being protected, those orders, even to know about them. The DA said that he thought that that was actually already enshrined in Marcy's law. I don't know if you had a specific response to that, or if there could be just a way to make it better, as I guess, regardless of whether or not it's in Marcy's law. I guess it's not happening sufficiently. So I guess what would be your fix?
Yeah, I mean, a couple of things. One, I mean, I very much agree with what Ms. Hardwick just said about, yes, we are making strides in terms of what we're doing with law enforcement and the trauma-informed training, but there is so much more to be done. I mean, when you look at, and when in your question about what can we do from a legislative perspective, I mean, one of the things that comes up for me as I look at the frequency with which law enforcement officers respond to these types of crimes, these interpersonal violence crimes like domestic violence or sexual assault crimes, compared to the amount of time that is spent in their basic academy training on addressing these types of crimes. And they are nowhere near proportional.
Just to clarify, the
Yeah.
domestic violence crimes are a large portion of what
Yes.
police officers do and a small portion of their training.
Correct. Most law enforcement officers, if you talk to them, they will anecdotally say it's somewhere between 80% and 90% of what they respond to is one of those is a domestic violence or sexual assault type of crime. And in their, initial police academy training, they spend 4 to 6 hours. talking, and that's a 6-month academy, 4 to 6 hours talking about how to address those types of calls. So that's how disparate that early training is. And many of them obviously can continue to get ongoing training about it. But just this morning, I was at a presentation from our Domestic Violence Prevention Council here in Sacramento County, talking about the fact that these are perishable skills in our law enforcement agents, and they need to continue to have that training, both the officers that respond, the detectives that investigate, the DAs that prosecute, the judges that hear the cases, all throughout the process. So I very much support what Ms. Hardwick was referring to, and I agree with the soft rooms. They make all the difference. In terms of the question about Marcy's Law, I think, I agree with the ideas raised by the DA. And I think to the point of, timeliness of when victims are advised about this, I think that's a critical aspect. I mean, we have victim witness advocates across the counties involved with the DA's offices. And those are really crucial resources for many of our victims, and a really important place where victims can be advised that, yes, they have these rights enshrined in Marcy's Law, but many of them are rights that need to be affirmatively asserted by the victim. And if they're not affirmatively asserted, then they basically are worthless. It sounds dramatic to say that, but they kind of are. They don't have any teeth. Nobody's going to come and do it on behalf of the victim. And for so many victims, this is their first and maybe only time they interact with our legal system at all. So they don't know it. They're not lawyers like many of the people on this call. They don't know that they can even do that. And they've also been through something traumatic. So they're trying to heal from whatever their trauma is and learn how to navigate a system that they're not familiar with. So I would support something that drives an obligation somewhere along the process whether it's a judicial officer at an arraignment or at a settlement conference stage or a status conference stage, asking who has communicated with this victim and to what end.
Right. I just wanted to interrupt there for a second. Sorry.
Sure.
I mean, it reminds me of what were you present when the DA was right?
Mhm.
Right. Of course, he wants that kind of warning or that kind of colloquy to happen at the sentencing phase. But you're saying, and I'm quite unfamiliar with the protective order process, but that squeezed in somewhere in there, something along the lines of what he's saying. Is that basically what you're suggesting?
Similar. So in the criminal protective order universe that I see is in the context of domestic violence, criminal domestic violence. And typically those protective orders are issued at arraignment. So when someone's arraigned for domestic violence crime, and they're sort of issued as a matter of course. Frequently, the victim is not there at the arraignment because it's usually right after somebody's been arrested. They don't even know the arraignment's happening. And so the restrained person is served with notice of the order, which of course is important, but I would say 60 to 70% of those victims that then come to my agency for services have no idea that they're protected by a restraining order or what it says, because they don't have a copy of it. They don't even know that one has been issued. So we have to go track one down. We have to track it down for them. We have to help them figure out what it says, and that's a really valuable tool for them. We have to help them get connected to the victim witness advocate that can support them, and then get them involved in the process. And then many other times they'll be, just as the DA was describing earlier there, and I understand, things move fast. I'm a litigator too. You want to strike while the iron's hot and you got a deal on the table. And many times, especially in domestic violence cases or in sexual assault cases, there's a very real person who is very really impacted and will be very really impacted by the outcome of whatever the deal is that's struck. And they are definitely the person in a domestic violence case who is most knowledgeable about what is going to keep them and their family safe. And they're frequently not consulted about what should be in a protective order or what should be, whether the felony domestic violence charge should be pled down to a misdemeanor, which happens commonly, or whether informal probation is really going to keep them safe, which means their perpetrator has no assigned probation officer and is just kind of out there floating around, assuming they don't do anything bad again. So those are places, or like there's lots of points of contact prior to sentencing where we could have that, that check-in by the court of, hey, where's the victim in this? Has anybody talked to the victim? Does the victim have anything proactively asking for that?
That makes sense to me, and I think really matches quite well with what DA was saying. Heidi?
Just one quick follow-up from Ms. Gephardt. Who would you propose are it seems like there's a lot lacking in the services and information being provided to victims and survivors along the way. Is it better for an organization like yours to be in charge of those services? We had the DA propose sort of a court taking a leading role, at least in the notification on a plea. Is the DA's office and their victim witness people, are they adequate to do it? They're just need more resources. Like, what is your proposed solution for how we provide victims with these notifications and services and understanding of their rights?
I think that's a great question. I mean, in this county, we have a really great relationship with our victim witness advocate program. I think there the biggest issue is just resources. But we have a high volume we're a large county like many of the other counties in this state. And we have a high volume. But I think utilizing that system is probably the most effective because they are connected to the district attorney's office, to the prosecutor's office. So there isn't going to be a pinch point in a flow of information. The hard part for an organization like mine is we have all of our extra confidentiality rules that come into play because of the type of funding that we receive. So we get funding under the Violence Against Women Act, which means I can't communicate with any outside agency about anybody I'm working with unless they sign a release of information. So I have a bunch of extra layers that I have to go through if I'm going to work with the DA's office around a victim that we're both supporting. Versus I can work with the victim and the victim can also be working with their advocate at the DA's office, and they can have a direct channel to whatever's happening in the proceedings, in the criminal proceedings. So I think it probably would be most efficient to better resource those existing victim witness advocates within our prosecutors' offices and create these proactive checkpoints within the judicial system, because we kind of already have the foundation there.
That's helpful. Yeah, I understand.
And Ms. Gephardt, go ahead, sorry.
It's kind of a follow-up, it's not really, just kind of cutting in, sorry. The proposal for the notification requirement prior to a plea agreement, a plea being entered, an agreed upon plea being entered, where would you rank that in the priority of the many needs and services that you have? This is open to the panel, have identified. The soft interviewing rooms, the early notice, the consultation on protective orders. There's a lot of things you've identified, and I'm just, obviously we all recognize there's limited resources, but I'm interested in where you'd prioritize that notification by the court prior to the entry of an agreed upon plea.
I mean, that's a tough thing to answer because they're all really, really important issues. I mean, obviously for folks where we're talking about intimate partner violence, where there's statistically significant data that suggests that for that person who was the victim, there's a high likelihood that they are at risk of being harmed again. It's really important for them, but that's not to say that all of these other issues are not equally important. So I don't know that I have a compelling answer for that.
No, I understand it's an impossible question. Allocation of resources is often an impossible task,
right.
But to some extent we have to tackle it.
Ms. Fleming, Heidi, are you done? Yeah. You were saying that many counties, not all, have CACs.
Mhm.
Are they required? Can you tell us what the legal framework is?
Yeah,
for how they're established?
absolutely. So not all counties have CACs. 14 do not have one in the state. They are not required. So the law does say you must have a multidisciplinary team response. So basically it just means law enforcement has to notify CPS and vice versa. And that tends to be kind of the bare minimum. We suggest they have CACs, and CACs were recently defined in the law, but it is a may and not a must for counties. We would love to see every county have a CAC. We know just that, like the topics that were already touched on, that the services to children, those trauma-informed skills, they need to be used really frequently. And talking to kids in the back of police cruisers or in not soft rooms with a man with a gun is not a good way to get them to talk about what is, one, probably the worst thing that has ever happened to them, and two, most likely happened by someone in their family. So we really love to see CACs because it removes a lot of those pieces and has better outcomes in the long run.
And just out of curiosity, are those 14 counties, are they the tiny counties that have very few people in them, or are they large counties that we should be very concerned about?
They vary. Size-wise, Imperial is probably our largest county, but it has less people in it.
Right.
And then some are like really tiny counties that don't have a lot of people in it. Oftentimes what happens in those counties is that either someone who's not trained to do this is taking care of it, or they'll go to a county next door, but that
Right.
means they're cherry picking cases.
Okay. Yeah, that's, I was wondering if that happened at all.
Yeah.
Okay. I guess I have one last question. I'm going to put it to you, Jess, because you haven't spoken much. We've heard a lot about accountability, right? And I think we're all kind of feeling that victims can't be made whole ever, especially, well, I suppose if you stole my bike, I could be made whole by returning my bike. But in serious and violent crimes, which are obviously the most traumatic, I think we throw around a lot of these words like accountability and dignity and respect, and they're in the Constitution, and then people ignore them. Or maybe even the best well-intended people just don't know how to implement them, respect them. I know you're not a lawyer, not a legislator, but you've been doing this for a little bit of time. Do you have thoughts about how we can get a government to be living up to these ideals in a more concrete way?
Well, accountability is such an important word, right? People often equate being held accountable with a prison sentence, like as if that's going to be the thing. And it actually rarely is. Like Annie and I have had so many conversations. The thing with people who are formerly incarcerated and actually currently incarcerated too, and the thing that often is the real difference maker is that somebody reaches out with an open hand and says, "Hey, do you need some help? Hey, can I give you some idea here or support you to reflect this process of a person reflecting, actually taking their own accountability, and it doesn't happen naturally in prison. It's not something that just people just think of. Like in prison, incarcerated people are often just trying to survive, and to have programming specifically that supports people to take real accountability is huge, right? There's just such a massive difference between places like San Quentin and the majority of the prisons in California and elsewhere, where there's just no programming and no opportunity for people to really reflect about the harm that they caused. And that's really, really essential, right? So much more can happen when people are open to really looking at their part in harm. And I'd love to hear, Annie, if you have anything you want to add to that.
Yeah, I mean, I would just say that a lot of the incarcerated organizers that I've worked with are these incredibly, they're credible messengers. They're people that could go back into their communities and actually help prevent violence. And it's because they've done this really courageous work, often with little to no support. And, it just would be in service of public safety for a lot of these people to be able to do that. But instead, they're kind of spending decades behind bars in spite of the fact that they don't pose a threat. And so I do think that, yeah, I think that, accountability is incredibly important. Also acknowledging that the majority of people who end up incarcerated are also victims. Our communities are so enmeshed. And so that's such a vital part of the process in order to actually create safety.
All right. Thank you all. Do any of the other committee members or actually even staff have any last questions before we move on? All right, we're all good. Thank you all again. I want to say what I said at the beginning, that you are not part of the system by choice. You are not part of, you don't want to be at this panel at all. Or maybe you do, but I appreciate that you're trying to make the world better, not just for yourself, but for others. And thank you. And I apologize for, the system that has let you down. So with that said, we're going to take a lunch break. Should we reconvene at 1:30? Is that too long?
That seems like a good idea. This is a busy and heavy morning. I think that's a good idea.
Okay. Thank you all. I should also say to all the panelists, if you have further ideas, further suggestions, want to be in touch with the committee, please do. We're reachable, and also to the members of our audience. All right. Thank you. See you at 1:30.
Thank you for sharing with us today.
Thank you.